Good, how are you? Good to see you. It picks up from pretty far.
No, it doesn't matter. Justin disappeared, so that's where we're at. All right.
All right, thank you and welcome. First, let's give a big round of applause to the two remaining nonprofits. As many of you know, Lawson is a great tradition here. It has produced numerous national champions, and I have no doubt that the future national champions are sitting in this room right now. So we are very excited to welcome you all to the finals for the Lawson Cup. I want to acknowledge a couple of folks who have just been integral to this. And first, I should have backed up. For those of you who don't know me, my name is Katie Powers. I'm the Assistant Dean of Advocacy here. Jeff Bloom is our Director of Advocacy, sitting on the second row as well. And we are honored to lead this program here. All of this hard work and all of the judging, we've got some of our judges who benched the later rounds in the room right now, but it was all really the product and hard work of Brian Bowden and Nadine Katak. So let's give them a hard It's also led by our advocacy president, Brian Boatwright, who also put in countless hours. Thank you, Brian. Literally, these guys wrote the problem, got the judges, had all the scoring, had all of the matrix, the master matches, and everything to that extent. And so it's really about the two of you today, but it's also about our Lawson editors. So with that being said, I'm going to turn it over to Brian.
Hey everyone, thank you for showing up and welcome to the 2025 Lawson Moot Court final round. As Katie said, my name is Brian Bowden. I'm one of the co-editors for this year's Lawson problem. My fellow co-editor, Nadine Katak, cannot be here, but I can assure you this problem and this competition would not have been possible without her. I also want to give a thank you to all the student preliminary round judges for giving us your time last weekend to help judge the preliminary rounds. I would also like to thank Professors Carlson, Fleissner, and Byers for helping judge the elimination rounds. To all the competitors, congratulations and thank you for a great competition. We started with 46 competitors, and after exactly 100 rounds, we are down to our final two. Last night we had an incredible semifinal round, and I'd like to congratulate Kane Bagley and all of Portwood on making the Final Four. That's an incredible accomplishment as well. This year has been a very hard-fought and competitive competition. The top 16 spots were separated by less than 1.5 points, and several of the elimination rounds were decided by mere decimal points. Reaching the final round is a huge achievement, so congratulations to Yomna Al-Medini and Taylor Cash on making it here. This competition not only decides the winner of the Lawson Cup, but also serves as tryouts for joining the Moot division of the Mercer Advocacy Program. This year's group showed a ton of talent, and they will undoubtedly continue the program's success. We have an exciting final round for this afternoon. Mercer has the privilege of welcoming a distinguished panel of judges, including Honorable Judges Todd Markle and Stephen Dillard from the Georgia Court of Appeals, Doc Schneider, a longtime King and Spalding partner, and Talia Levine, last year's competition winner. So with that, have a great final round, and good luck to you two. All rise. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you very much. You may be seated. All right, counsel, we're ready to rock and roll.
Thank you, Chief Justice, and may it please the court. My name is Yomna Al-Medini, and I represent the state of Georgia in this case, the petitioner. The petitioner kindly requests 2 minutes for rebuttal. The state respectfully asks this court to reverse the 14th Circuit's decision for the following 2 reasons. First, this court has historically held that in certain categories of speech similar to true threats, there is an objective standard. Second, a subjective standard ignores harm irrespective of the speaker's intent. Your Honors, this case is about the necessity of an objective standard to ensure that the First Amendment is not used as an unyielding shield for those who inflict terror under the guise of ambiguity, when its rightful purpose is to protect the right to speak, live, and move freely without the looming shadow of unchecked threats.
Where's the demarcation line, though, counsel? I mean, that's what concerns me about your standard is do we have enough of a buffer between what's a threat and what's free speech and kind of what's in between that? Like, does your test make sure that we are protecting a robust free market of free speech?
Yes, Your Honor, it does. That is because true threats, as defined in this court's 2003 decision of Virginia v. Black, is a serious expression of an intent to commit unlawful violence. Your Honors, the standard of review in this case is de novo, meaning this court will treat the legal issue anew. Beginning with my first point, and it's that this court has historically adopted an objective standard when it comes to cases similar to true threats. If we look at the 2003 decision of Virginia v. Black, this court has found that certain categories of speech, including true threats, may be regulated for their harmful effects, as opposed to the speaker's state of mind. Your Honors, this court has never adopted a subjective intent requirement for categories of speech similar to true threats. For instance, the 1942 decision of Chaplinsky v. New Hampshire, or even the 1971 decision of Cohen versus California. This court determined in those cases of fighting words that they may be punished when they are inherently likely to provoke violent reaction. Or for instance, in the cases of obscenity, those cases are determined by whether an average person applying contemporary community standards would find the material to be excessively salacious. The exclusion of true threats from First Amendment protection is because they provoke fear, disorder, or potential violence. Those are all factors that do not depend on a speaker's intent. If we look at page...
Counsel, let me ask you, what was the specific threat?
Yes, Your Honor. The specific threat were words, if we look at on page 8 of the record, careful who you disappoint. You'll regret treating people this way and die.
Well, no, die was separate, right? I mean, those are two separate sentences, right?
Yes, Your
Die
Honor.
was a standalone, okay. Did that alone saying die, I mean, that doesn't necessarily mean that he's saying, I'm going to kill you. It just says like, I hope you die. You could read it that way.
Yes, Your Honor. However, if we look at page 7 and 8 of the record, what we will see is that these messages were insistent. He didn't just send 1, 2, or 3 messages, but rather it was hundreds of messages that occurred over 2 years. And although that they began as affectionate, they became insistent and then threatening. And while it's just the word die, if we look at the broad context of his communications, the word die itself, it doesn't elicit forms of compassion or care or kindness. And for that reason, it is a true threat.
Didn't he say he wasn't really trying to threaten her? He would never harm her? Doesn't that sort of deep dive all those remarks?
Yes, Your Honor, he did. He sent that message after he said die. However, if we look at the context here, the very fact that he was able to send that message after he said die does invoke a premise that he is an arbitrator of violence. There is a power to being able to give and take away violence. And so the very fact that there is a power dynamic does express that there is a perpetrator and a victim. Therefore, it is a true threat.
If we rule against you and find that there is a requirement of at least some subjective intent and some strike, do you lose entirely?
Your Honor, perhaps we do lose. However, so is society. Effectively, what the 14th Circuit's decision is saying is that a speaker's unspoken intent is more important than a victim's undeniable fear.
Are you making a policy argument or a legal argument? Because it sounds like a policy argument. I mean, that's not, we don't do policy.
Your Honor, no, I'm not making... Your Honor, actually I am making both a policy argument as well as a legal argument. Because true threats are similar to other categories of speech that are not protected under the First Amendment, and for that reason it should not fall under a subjective intent requirement. However, it is a policy argument because this does affect American society.
But so does restricting free speech. I mean, I understand this isn't like a nationwide celebrity here, it's more of a local celebrity, but I mean, you're advocating, I mean, if you are out there in the public, even as a local singer, you're subject to criticism. I mean, you're subject to people wanting to contact you. So it seems there's also a policy danger here in having a test that ends up freezing or restricting speech. That also impacts our country.
Yes, Your Honor. However, in this circumstance, it is different because what we are looking at is messages between two individuals. This isn't messages that are happening publicly as we look at the case of the 2015 case of Alonis versus the United States, where in that court they deemed that a subjective intent requirement was utilized, but that was because the speech was happening on a public forum. If anything, this would not infringe on this right to speech because what we're looking at is messages that were insistent and repeated and dangerous, and they do invoke a serious expression of an intent to commit unlawful violence.
Why didn't you just make her account private? If she made her account private and selected, I mean, there are ways and privacy controls with social media that can where you can restrict speech rather than having the government do it.
Yes, Your Honor, but in this circumstance, Roan had repeatedly blocked him and also distanced herself from him. So she did take every precaution that she could have on the digital platform. However, Cyrus continued to be insistent, which draws me to my next point, which is that a subjective standard ignores that true threats cause harm irrespective of the speaker's intent. If we follow the respondent's approach, we would effectively be saying that anyone who sends repeated menacing messages could escape prosecution, which would go against this court's decision in 1974 of Gertz v. Robert Welch, where this court has stated that the state has an interest in protecting individuals on issues of true threats. If we look at page 8 of the record, Roan's fear is not speculative. It altered her daily existence. She canceled performances, which was not only her source of income, but it was her passion. She experienced severe emotional distress. She stayed at home. This is harm that reasonably conveys a threat of violence, and it arises irrespective of
That's her
Cyrus's...
subjective reaction. That's not we're not looking at, the question is, you see what I'm saying? You're talking about her subjective reaction. So how does that play into your argument?
And counsel, off of Chief Justice's question, wouldn't we want to add the subjective element, because don't we typically in our First Amendment cases err on the side of protecting speech? Wouldn't we want that extra layer of protection so we don't chill free speech?
Your Honors, going in turn beginning with Chief Justice, this would not be subjective, because if we look at the totality of the communications, it does show an intent to commit unlawful violence. And for that reason, though it's Ms. Roan's subjective experience, there was a jury that determined objectively that there was an intent to commit unlawful violence. Your Honor, may you please repeat your question?
Of course, counsel. Wouldn't we want to add the subjective element, because in our First Amendment jurisprudence, we tend to err on the side of protecting speech. So why wouldn't we want to protect that speech so we're not chilling free speech?
Your Honor, respectfully, the only thing chilling about this matter are Cyrus's messages. May I briefly respond to your question, if that is all right?
Sure.
Thank you. Your Honor, we would not be chilling free speech, because there are certain categories that are not protected under the First Amendment and that are similar to true threats. And so, for that reason, we would not be chilling the free speech. And for those reasons, the petitioner kindly asks that this court reverse the decision of the 14th Circuit. Thank you.
Thank you, counsel.
And you reserve time, is that correct? 2 minutes?
Yes, Your Honor. 2 minutes for rebuttal.
Thank you.
Thank you, Chief Justice Dillard, Your Honors, and may it please the Court. My name is Taylor Cash, and I represent the respondent, Billy Raymond Cyrus. Precedents and standards are the issue for the basis of the rule of law in this country, especially when it comes to protecting the people's First Amendment right to free speech. This is especially seen in how the court has developed a standard for speech that is not protected, such as seen in obscenity, defamation, and cases of true threat. The first issue before the court is that the court should hold that cases of true threat require proof of subjective intent. And second, even if the court holds that the cases of true threat require objective intent, the messages sent from Mr. Cyrus to Ms. Roan do not constitute true threats. First, to the subjective intent element.
Counsel, let me ask you, on the subjective intent, so he just says he didn't, even though he said the word died, he didn't intend any harm by that?
Well, first, Your Honor, that would be a question for the jury to weigh. The fact finder would weigh that evidence. In order, with the subjective intent element, the fact finder would have the information of both the alleged threat that the state is accusing the defendant of, as well as the information contained where the defendant is stating, I did not mean harm, or I was just joking. They would weigh that evidence and come to a decision based on a subjective test. In order to address this issue, we turn towards the First Amendment. In the history of this country, this court has set a precedent of establishing a relationship between subjective intent and issues of not protected speech. This is seen in obscenity and defamation. Starting with obscenity, this court has held that obscene speech and materials are not protected. And this court held in Hamlin versus United States in 1974, as cited on page 12 of the record, there must be evidence of the defendant's awareness of the character and nature of the materials distributed.
Counsel, isn't it true that, well, we agree that true threats are not protected by the First Amendment, right? You and I agree with that, okay. So isn't it true that almost nearly every other category of unprotected speech is restricted, has to be restricted using an objective standard? So why would we use a subjective standard here?
Well, Your Honor, for example, in obscenity, there is both an objective and a subjective standard in obscenity. An obscenity that measures if the content of the message is obscene to a reasonable person, as cited in this court in Smith versus California in 1959 on page 12 of the record. However, there is also an objective element, as cited by this court in Hamlin versus United States. This court held that the defendant must have an awareness of the character and nature of the materials that they are distributing or speaking. This indicates a subjective intent. This is further affirmed by how this court handles defamation.
Well, that's, I mean, in the obscenity case, all that's requiring is that they be aware that they're distributing obscene material. There's not an evaluation of whether they have subjectively intend to play to prurient interest, etc. They're not evaluating that intent, just awareness of the remarks. You're not saying that Mr. Cyrus was unaware of what he was saying, are you?
No, Your Honor. Mr. Cyrus maintains that he was not threatening Miss Rome. However, in cases of true threat, as this court held in Virginia versus Black in 2003, a serious threat must be an expression to convey that the speaker means to commit an act of violence. In determining what someone means, we must look at it subjectively. And drawing the analogy to obscenity in this case, obscenity has both a subjective and an objective element in its text.
Well, let's look at what you're trying to protect in this case. Is there a First Amendment right to bother the hell out of somebody, so long as you're not threatening? Is that what you're saying there is? That there's a person, and we shouldn't chill that right?
Your Honor,
What are we protecting here?
Your Honor, we're protecting the ability for people not chilling the First Amendment rights of people. The threat of criminal prosecution for making a false statement can inhibit the speaker from making true statements, which chills the kind of speech that's protected by the First Amendment. If someone states something like, I'm going to kill my sister for taking my clothes, or my father, when watching a UGA football game, states he wants to take out the quarterback from Alabama, objectively viewing those statements in a vacuum is not proper in this case. We are asking the court to hold that these statements are evaluated from a subjective standard. We're not asking the court to hold that these statements that people are just freely able to harass people, because the court we have other laws and protection for that. However, to define a true threat, it must be a serious expression that that person means to commit a serious violent act against that person.
Well, I mean, tell me about these, I don't want to be outside the record or anything, but tell me about these laws that allow the state to regulate you from harassing people. Why would you be allowed to do that freely without any subjective intent element, etc., but not here?
Well, Your Honor, as this court held in Alonis versus United States in 2015, in order to determine the criminal culpability of a person, there must be an element of subjective intent. What this court looked at in Alonis is determining what innocent conduct is differentiated from non-innocent conduct or criminal conduct.
Well, couldn't that be the case? In the Alanis case, wasn't the court sort of interpreting what the statute required as opposed to what the Constitution required?
Yes, Your Honor, the statute in Alanis was evaluated, and there was a difference in the manner of how the messages were communicated. Mr. Alanis was sending the messages over Facebook as opposed to personally. But however, that is not a dispositive fact in this case. We are asking the court to hold that the standard of the case is evaluated from a subjective intent. The fact that the message was evaluating, the statute was being evaluated is not dispositive into holding that true threats are serious expressions that the speaker means to commit in a violent act.
But Counselor, I mean, if we do hold that there's a subjective element that's required, aren't we giving everyone effectively a carte blanche to threaten however they want, so long as they say, well, I didn't mean it? I mean, where do we draw the line as to what's subjective and what's not for a true threat?
Yes, Your Honor, the line is drawn for the jury. The jury will have the evidence of both the statement that the state claims is the alleged threat, as well as the message that the defendant states that they were just joking or did not mean any harm. By giving the jury the determination to weigh those factors is what the subjective intent implies, and that is also what criminal liability is concerning in this case.
Well, the jury here in this case found that on an objective standard, that there was intent, it was a threat, a criminal threat. And you're arguing, well, the jury should have had been instructed that they didn't find subjective intent. Are you arguing here that the case should be remanded so that the jury can decide the case with that proper instruction, or are you saying you win outright because the district court said on the face of the record the statements were not enough to infer subjective intent of a threat? What are you arguing here?
No, Your Honor, we're not asking for it to be remanded back to trial court. If this court holds that the subjective intent element is required for true threats, then the state of Georgia would have to rewrite the law that Mr. Cyrus was charged under, which stated on page 7 of the record, the law itself is stated from a reasonable person standard. Once that law is rewritten, that would be up to the state of Georgia for this case. We are asking the court to affirm the 14th Circuit Court's decision. Furthermore, Your Honor,
Counsel, if I may jump in, is it correct in the analysis to say that the subjective element that you're arguing we should apply to affirm the lower court is in essence an analysis of the intent of the speaker, and the objective test is an analysis of the effect of those words on the person to whom that was communicated, the speech was communicated? Am I saying that right?
well, Your Honor, the way that Georgia has written the statute in this case is that it causes a serious emotional distress on the person who received the communication. Currently, we are asking for the court to hold that the person speaking the messages, who are communicating the messages, is held from a subjective intent. We do not have any issue with the remainder of the statute stating that it should be held from a subjective standard of whether or not that person suffered severe emotional distress. However, if this court does hold that a person's statement can be evaluated if it caused severe emotional distress, that in itself is a subjective standard, and it is only fair that the person is being held to a subjective standard that communicated that speech.
Why do we care about the subjective intent of your client? I mean, isn't the importance what the statements that he made convey for First Amendment analysis? Isn't that really what we're looking at?
Well, Your Honor,
going back to my fellow justice's point about, doesn't this just give carte blanche to people if they can say, well, that's not what I meant. I said, I want you to die, but I didn't mean it that way. I mean, don't we care about the plain meaning of the words that are conveyed in the speech?
well, Your Honor, in order to hold someone criminally liable as seen in Alanis, there must be evidence of the person's subjective intent. Evidence of intent and the purpose for issuing that threat.
But why doesn't that come from the words themselves rather than what the person, their mental state?
Your Honor, it depends on how the fact finder in that case would evaluate both the statement. We are just asking for the fact finder to be able to subjectively evaluate the intent of the person. Holding for the petitioner would reject the notion that the First Amendment precludes punishment for criminal liability unless the speaker's words were intended, not just likely, to produce imminent disorder. The same theory applies in this case. This is a precedent upheld within several rules of law in our nation, and it would be asking for the court to go back on more than a century of setting the standard of precedent requiring evidence for subjective mental state in order to restrict speech. For those reasons, we ask the court to affirm the 14th Circuit Court's decision and uphold precedent. Thank you.
Thank you, Your Honors. Beginning firstly with a question that was asked in terms of the plain meaning. The plain meaning does matter, because if we look at the word die, subjectively and objectively, it is not a word that invokes ideas of compassion, kindness, or care, but rather of aggression, harm, and violence. Your Honors, the respondent's argument relies on this idea that without a subjective intent requirement, then speech would be chilled. However, in this court's 1942 decision of Chaplinsky versus New Hampshire, in this court's 1971 decision of Cohen versus California, in this court's 2003 decision of Virginia versus Black, and this court's 2015 decision of Ellis versus United States, this court has held that there are certain categories of speech, including true threats, that may be regulated based on their harmful effects, irrespective of a speaker's intent. To hold that the First Amendment in true threats actions requires a subjective standard is to say that the law will wait. It will wait for an explicit admission of an intent to commit unlawful violence while victims' lives are disrupted. They live in fear, and their voices silenced. That is not liberty as the respondent so fondly speaks of, nor is that justice. And for those reasons, this court should reverse the 14th Circuit's decision. Thank you.
All right. Anything else we need to do? You're our sergeant at arms here.
We'll go back and forth.
All right, we'll consider the matter. Thank you very much. Session, everybody be seated. All right. Guess we'll do some comments just to give you some feedback. I'll start down here.
First I just want to say congratulations. I was in y'all's shoes last year, and I know the week you've just been through, and so I just cannot congratulate you both enough for making it through the week. You both were phenomenal. Start to finish, I was very impressed. Yumna, your just persuasiveness and the way that you were presenting the law, I felt like it really helped like frame the case, and I really believed what you were saying because you were so persuasive, especially in just your word choice was fantastic. And I mean, you came up on rebuttal, and I was just blown away. I mean, I felt like that was your mic drop moment, which is exactly what you want that last line of your rebuttal to be. So I mean, I just thought that was fantastic. And Taylor also, I mean, fantastic. Your confidence right out the gate gives you such a strong start. And that is so important because it's your first impression to the court. But I also just really want to commend you on your knowledge of the law. It is very challenging to know the whole record and all of the cases and the facts and the holdings and just all of it. And you were just spitting it out from start to finish. I felt like every time you answered a question, you had law to go with it. And that is so huge. But yeah, I just want to commend you both and huge congratulations today.
I agree. Excellent job by both competitors. Yana, I guess that's your first name, and your last name is what? Is your? Ahmedine. Excellent job. I thought that occasionally you would get not overwhelmed, but a little perplexed by the questions that were coming at you. But I think you showed amazing calm and also poise, and at one point answering the Chief Justice's question, and then going back and having the courage to say, please repeat your question, as opposed to trying to answer some flimsy part of it that you might have remembered in your mind in the heat of things. So I thought that was excellent. Your rebuttal was superb. I thought that your turns of phrase, your repetition of in the case of so and so, in the case of so and so, in the case of so and so, and that is neither justice nor freedom, as however you ended it. I thought was perfect, and I think that if you script so much, as if you have those kind of little nuggets of speaking points that you can return to in the questions that are being posed to you. It's helpful, but I mean, I thought your preparation showed, and certainly your passion for this person who's being annoyed the hell out of by Billy Ray Cyrus for no good reason. Taylor, I thought you did an excellent job. You were a very good advocate. Your preparation showed. I thought you were a little bit stiff at first, but you got into the swing of things, and your passion for it showed. We asked you some difficult questions. I think your knowledge of the Alanis case was good, very deep knowledge, and you thought about it, obviously. You also thought about the result you wanted, because a lot of times we can get up there and be arguing a case and not know what the hell it was we want the court to do. So I think that you already obviously thought through that and answered that very well. So I commend you for that. I think that both of you today showed something that's a very important lesson, which is look, all the energy you have poured into this since February 7th until today to deliver an argument as good as you did is what it's going to take to succeed in law school, to be great lawyers, to be dedicated to your clients. And this is a learning experience today, and that's the best thing about it. So congratulations for showing me how much can be learned in such a little bit of time. Because after all, you finished your first semester, first year, so you're in the middle of the first year. You're doing marvelously. So congratulations.
Sure, starting with Yana. Mr. Schneider used a couple of the adjectives I would have used. What I was thinking, I was amazed that we were of like mind on that, but it was fairly obvious. You had a lot of poise in your presentation and a lot of passion, and I really that came through loud and clear. I think you'll make a very good advocate in the future. Did a fine job there. And Taylor, I think the word that comes to mind to describe your performance is you're very good at pivoting, and you did that seamlessly as you moved between your thoughts and the arguments that you wanted to make. You had a command of the facts and the law, and I think that came through loud and clear, and it was a pleasure to hear you both.
I don't think I can improve on any of that. I thought this was an extremely close competition. It was very hard, for me at least, to pick between the two of you. You were both really excellent, and you should be proud of your performances today. All right, are we ready for the big announcement? All right, so the winner is Taylor. Congratulations, well done. Well done.
All right, if we can have everybody, please stick around for some photos, and I know everybody wants to speak to them and congratulate them, but if you'll just give us just a couple of minutes to get some pictures, and then we can certainly celebrate.
I should like to say that like a golf tournament, all the winners here and those who came in second get checks, so.